Hello and welcome to Blackstone Solicitors. One email, that is often how it starts. A message from your club secretary or welfare officer telling you that a safeguarding concern has been raised and that you are subject to an internal investigation. For coaches, volunteers and club officials, that moment can feel overwhelming. Your mind races. What has been said? Who has complained? Will this affect my job? My DBS? My reputation in the sport I love? Safeguarding in sport is, quite rightly, taken extremely seriously. Governing bodies such as the Football Association and the England and Wales Cricket Board have strict policies designed to protect children and vulnerable adults. Clubs are under pressure to act quickly and decisively when concerns are raised. That urgency, however, can sometimes lead to rushed decisions and unintended unfairness. We can act for grassroots football coaches suspended within hours of an allegation, only for it to emerge later that the issue was a misunderstanding about appropriate physical contact during a training drill. We can also advise on swimming coaches investigated after messages were taken out of context in a parent's WhatsApp group. In both situations, the individuals were dedicated professionals who suddenly found their integrity questioned. So, what should you do if you find yourself under investigation? First, do not panic and do not respond emotionally. It's completely natural to want to fire off a defensive email or even confront the person who raised the concern, but really, you must resist that temptation. Anything you say at this stage may form part of the investigation record. Second, obtain and read the safeguarding policy carefully. Every club and governing body must follow its own published procedures. The process should outline how complaints are handled, whether you will be suspended pending investigation, how evidence is gathered, and whether you will have an opportunity to respond. If the procedure is not followed correctly, that can be highly significant. Third, seek legal advice early. Safeguarding investigations can overlap with employment law, regulatory proceedings and, in serious cases, criminal law. A poorly handled response can have long-term consequences. We have seen cases where an internal club finding was later relied upon by a national governing body, placing someone's entire coaching career at risk. It is also important to understand the standard of proof. Internal safeguarding inquiries are not criminal trials. The threshold is usually the balance of probabilities. That means a finding can be made even where there is no police involvement. Protecting your reputation therefore requires a calm, structured and evidence-based response. In some cases, temporary suspension is imposed as a neutral act while investigations are ongoing. That does not mean guilt. However, suspensions can quickly become public within a club environment. Managing communication is crucial. We often advise clients on how to address parents, colleagues or committee members without breaching confidentiality or inflaming the situation. Most safeguarding investigations are resolved fairly and professionally. But when procedures are flawed or conclusions are disproportionate, there may be grounds to challenge the outcome through internal appeals or, in certain circumstances, external legal action. Your reputation in sport can take years to build and moments to damage. If you are facing a safeguarding inquiry, the key is not to retreat or react, but to respond strategically and with proper advice. At Blackstone Solicitors, based in England, we support coaches, clubs and sports professionals through safeguarding investigations with discretion and clarity. If you found this video helpful, please like and subscribe for more insights into the legal side of sport, and if you need advice, do get in touch.